5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, counsel. Before we call the case, we don't anticipate any technology problems, but if we should have any, just make sure you let Mr. Hivner know if it's on your end, and we'll take a pause till we get it resolved. Mr. Hivner, call the case, please.
George Gary Ingram versus Dr. Michael Gallagher et al. We'll hear from the appellant.
Hey, please the court. Neil Thomas from the Chattanooga Bar representing the appellant. This appeal is an appeal of healthcare liability case from the grant of summary judgment in the court below, which dismissed the complaint. It involves a chain of events which I will describe, but each of which was taken in response to the prior one. This case was started by the filing of a complaint, obviously. And after the filing of the complaint, a voluntary dismissal was taken as to all defendants except for Dr. Gallagher. When Dr. Gallagher when the remaining defendant, that is Dr. Gallagher, answered and asserted that he could not be named as a defendant without naming the hospital for which he worked, a motion to withdraw the voluntary dismissal was made pursuant to Rules 54 and out of an abundance of caution 60. That motion was denied, and that's the first of 4 issues which we will present on appeal. If that denial was incorrect, then the remaining issues are not posed for this court because that will put Erlanger back into the lawsuit as the employer of Dr. Gallagher, and we need not resort to the remaining issues that were raised on appeal. And as I said, each one of those issues was in reaction to the prior action of the court below. Our contention is that on that first issue, that an order of voluntary dismissal is an interlocutory order under Rule 54, which could be modified at any time under the language of the rule before the entry of a final order in the case. Our contention is that the motion to set aside the interlocutory order was made immediately after the answer of the remaining defendant, that is the doctor, who asserted in his answer that he could not be named in the complaint under the Governmental Tort Liability Act without naming his employer, Erlanger Hospital. And so the motion to set aside the dismissal of Erlanger was made less than 2 months after the filing of the complaint. Our contention is that the motion should have been set aside, and there is a paucity of decisions in this area involving interlocutory appeals, or interlocutory orders, excuse me. The only one we could find even close was a decision by Justice Barker, which said even a motion for summary judgment was an interlocutory order. It can be considered at any time. Our suggestion on this is that since a voluntary dismissal is under the control initially of the counsel for the dismissing party, and since, as pointed out by the appellees, the entry of the order after that is a ministerial act, then the voluntary dismissal should be able to be set aside unless, and I'm not even sure this is required by the rule, but unless there is prejudice to the parties as a result of the withdrawal of the voluntary dismissal. That was the contention that we made in the court below. The court disagreed with us, so we proceeded to the next step. And the next step was to say, well, let's add Erlanger back in pursuant to a motion and base it upon the saving statute and upon the Rule 15 itself to relate back to the filing of the complaint in order to avoid the issue of the bar of the statute of limitations. The immediate argument was made that under the GTLA, the saving statute does not apply. Our response to that was, it does apply in a Healthcare Liability Act case, because if the GTLA is amended to provide that the hospital must be made a party in addition to the doctor, that means that if the doctor is subject to the saving statute and the saving statute can be used against the doctor, it can be used against his employer who is being brought in for derivative liability as well. And that constitutes a waiver by the legislature of the requirement that, or the provision that the saving statute is not applicable to the GTLA. So our contention is that it is. Now, we also contended that any amendment should relate back under Rule 15, and for that, we relied upon misnomer and mistake to relate it back to the filing of the complaint. Well, obviously, the court below disagreed with that as well. So the ultimate motion that was made before the final disposition of the case was to allege fraudulent concealment on the part of the defendants in order to toll the statute of limitations. That motion was granted. After it was granted, then Erlanger came in and said, well, wait a minute, you didn't provide the necessary pre-suit notice and the necessary pre-suit notice. Our position on that is, since they are still in the case, it's an interlocutory order, no pre-suit notice is necessary because notice had been given, and in any event, substantial compliance with the Healthcare Liability Act would have been satisfied. So in coming back around complete circle now, we have asserted that Erlanger should have been brought back in. They were brought back in. Then on motion, they asked to be let out because of the failure to give pre-suit notice. Once the court below agreed with that, the court below found that the doctor should be let out because Erlanger had been let out because it was a necessary party. There is one additional argument that we made on the application of the addition of the hospital under the GTLA, and that is it relates to the language of the statute itself. And for this, I would go back to some of my teachings from too many years ago, which I will not state how many, but in any event, it's a grammatical construction, and I would submit that for the GTLA to apply to provide that the hospital must be named, in all instances, you have to disregard part of the statute. Now, that statute says, no claim for healthcare liability may be brought against a health care practitioner unless, and that's a key word, the amount of damages sought exceeds the minimum limits set out by 2920-403 or the amount of insurance coverage actually carried by the governmental entity, whichever is greater, and the governmental entity is also made a party to the action. Our contention there is if it's excess that's sought against the practitioner, that under the language of the statute, using that word unless the amount of damages sought exceeds the minimum limits or the amount of insurance, then the hospital has to be brought in. But if it does exceed the minimum limits, the hospital does not. So at our last argument was we would not seek liability except in excess of the minimum limits of the governmental entity which should have been brought in. That, in a nutshell, is our argument, Your Honors.
All right, thank you. You have your time for rebuttal. We'll hear from the appellee. Reynolds, you're muted. You're still muted.
Pardon me, Your Honors. Your Honors, may it please the court, Drew Reynolds here on behalf of defendants appellees, Chattanooga-Hamilton County Hospital Authority, DBA Erlanger Health System, which I will refer to as Erlanger, and Dr. Michael Gallagher, who I will refer to as Dr. Gallagher. The issues on appeal relate to the consequences of plaintiff appellant's decision to voluntarily dismiss Erlanger, as well as plaintiff appellant's attempts to undo the effects of this voluntary dismissal. So today I will explain the consequences of the voluntary dismissal of Erlanger, as well as the reasons why the various procedural maneuvers attempted by plaintiff appellant cannot undo the effects of Erlanger's voluntary dismissal. Before moving to the issues in argument, I want to provide a brief recitation of relevant facts. On or about July 6, 2018, plaintiff appellant attempted to provide written notice of a potential claim to several healthcare providers, including Erlanger and Dr. Gallagher. On or about November 14, 2018, plaintiff appellant filed suit against several healthcare providers, including Dr. Gallagher, Chattanooga Neurosurgery and Spine Group, and Erlanger. In the initial complaint, plaintiff appellant alleged in pertinent part, upon information and belief at all times relevant herein, Erlanger is and was the owner of the Spine Group, meaning Chattanooga Neurosurgery and Spine Group, and its employees were either employees of Erlanger acting within the scope of their duties as employees of Erlanger or employees of the Spine Group only while treating plaintiff appellant. Upon information and belief, the Spine Center employees referred to in the preceding sentence were Dr. Michael Gallagher and physician assistant Anita Jones. Before any answers were filed or even due, and before discovery was conducted, plaintiff appellant made the decision to voluntarily dismiss Erlanger and Chattanooga Neurosurgery and Spine Group, the two entities that were alleged to be the employer of Dr. Gallagher. The voluntary dismissal of Erlanger created a problem for plaintiff appellant because Erlanger is a governmental entity. In that regard, Dr. Gallagher asserted Erlanger's absence from the case as a defense pursuant to a provision of the Tennessee Governmental Tort Liability Act, which I will refer to as the TGTLA, that is section 292310B, in his answer. Following the assertion of this defense, plaintiff appellant attempted various procedural maneuvers in an effort to undo the voluntary dismissal of Erlanger. However, the trial court correctly ruled that plaintiff appellant's voluntary dismissal of Erlanger could not be undone by any of these procedural maneuvers. Moving to the first issue in argument, the November 27, 2018 order of dismissal was not an interlocutory order that was subject to revision prior to the entry of a final order. Additionally, there were no grounds for revising the order. In an attempt to undo the effects of his voluntary dismissal of Erlanger, plaintiff appellant filed a motion to alter or amend on February 27, 2019.
Counsel, I'm sorry, let me take you back. Why was it not an interlocutory order?
Your Honor, it's not an interlocutory order because there's case law suggesting that or indicating that a voluntary dismissal is effective even prior to entry of the order. So essentially the orders.
So it's effective. Why is it still not under the rule? Why is it still not an interlocutory order?
Because the entry of the order serves only ministerial and procedural purposes. The voluntary dismissal is complete prior to entry of the order, and the Tennessee Rules of Civil Procedure actually indicate that the order is entered after the voluntary dismissal. So when the plaintiff provides a notice of voluntary dismissal, it's complete and effective upon providing notice of the voluntary dismissal.
And why is it still not an interlocutory order? There's still a lawsuit pending. It didn't resolve all the issues as to all parties, did it?
No, Your Honor. But it's an order essentially memorializing a voluntary dismissal. And if it's effective, if the voluntary dismissal is effective prior to entry of the order, then how can the order be revised to undo the voluntary dismissal? We would submit that it can't be.
So it's what? It's a final order or it's nothing? I mean, what are you saying? You're saying the order is immaterial?
I'm saying the order is only ministerial and procedural, Your Honor. It is there to trigger timeframes and deadlines, but the case law, for example, let's see, Ewan versus Hardison law firm indicates that the non-suit actually occurs prior to entry of the order. And a voluntary non-suit puts a party in a position as if he or she or the party was never sued. So essentially, with the party going to the position where it was never sued, before suit was filed, it's essentially the order is procedural and ministerial. It has no effect.
So are you saying that once the notice of non-suit is given, the case ceases to exist, period? You can't go back and do anything to it. And the order is just sort of there just to memorialize what's already happened?
Yes, Your Honor. And again, that's pursuant to Ewan v. Hardison law firm, where they specifically state the non-suit actually occurs prior to the entry of the order. So based on that authority, the voluntary dismissal of Erlanger was complete and effective when plaintiff appellant filed the notice of voluntary dismissal, which was prior to the order of voluntary dismissal, and it placed Erlanger in its original position prior to the filing of the action, as if suit had not been filed.
All right, I'm back to my question though. All right, I understand your argument that it was effective upon notice of voluntary dismissal. It was effective upon that notice. Why is that still not interlocutory?
Your Honor, if you classify it as interlocutory, I think it's a distinction without a difference. In other words, if a voluntary dismissal is complete upon the filing of the notice and the order only memorializes the voluntary dismissal, then the order cannot be revised. So in that sense, it is not interlocutory.
So if a defendant, one defendant among several, gets an involuntary dismissal, but it doesn't include any Rule 54 language, it just grants a motion to dismiss, involuntary dismissal. So in that case, it can be revisited, but if it's a voluntary dismissal, it can't be.
Yes, Your Honor, and that's because of the rule, the voluntary dismissal rule. There's case law holding that it leaves the parties, when a voluntary dismissal is filed, it leaves both parties as a suit had never been filed. So it's very different from an involuntary order.
Well, did you cite us in, I mean, your brief was very good. I'm not criticizing at all, but did you cite us to a case where there was a voluntary dismissal and there was only one defendant? Or excuse me, there was more than one defendant that said, once the notice is given, that's it. Plaintiff can't change their mind. They can't, I mean, they're just stuck. Even if before the order goes down, plaintiff is still stuck.
I believe plaintiff is still stuck, Your Honor, once the notice of dismissal has been filed. I'm not sure there's a case addressing that specific issue. There are cases addressing the effect of interlocutory orders in the context of summary judgment and those sorts of things. And they contemplate that the parties who are granted summary judgment are not truly in the case. They're in the case in the sense that the order could be revised, but they are also that summary judgment is given effect, in the sense that the parties could monitor the case. And there are cases that we've cited in the brief indicating that when a party is granted an interlocutory order of summary judgment, they're somewhat in procedural limbo. So I'm not sure the answer to that question is entirely clear or has been resolved.
Okay.
In any event, there's also authority specifically holding that plaintiffs may not obtain relief from orders voluntarily dismissing governmental entities like Erlanger. For example, in the Himmelfarb v. Allain case that we have cited in our brief, the Court of Appeal, or the Supreme Court of Tennessee, held that Rule 41 further limits the use of voluntary non-suits in certain situations. For example, a case may not be refiled following a voluntary non-suit taken in a governmental tort liability action. So again, just adding further support to the proposition that the voluntary dismissal in this case was not subject to revision.
In that case, it'd say why it couldn't be refiled. I mean, was it outside the statute or implications or what?
No, Your Honor, the Himmelfarb v. Allain case did not address that. It addressed several situations where voluntary dismissals relief cannot be obtained from voluntary dismissals under these circumstances, the circumstances described in Himmelfarb.
All right, in that case, it's cited in your brief, right?
Correct, Your Honor.
Thank you.
Additionally, as we say in our brief, there are no grounds for relief from the order. Under Tennessee, assuming that an order of voluntary dismissal could be revised, there are no grounds in this case. For example, Tennessee Rule of Civil Procedure 60, which was relied upon by the plaintiff in his motion to alter or amend, I believe. 60.01 is designed to afford relief from clerical mistakes and errors arising from oversight or omission. In other words, not the type of mistake we're dealing with in this case. 60.02, 3, and 4 are not applicable. And 60.021 relates to mistakes of fact, not mistakes of law. So we've cited cases in our brief holding that ignorance of the law or a mistake of law cannot be the basis for a 60.02 motion. So essentially, plaintiff appellant's decision to voluntarily dismiss Erlanger was not the result of the sort of mistake, inadvertent surprise, or excusable neglect contemplated by the rule. So in conclusion, the order of dismissal was not an interlocutory order that was subject to revision. Assuming arguendo it was subject to revision, there are no grounds to revise it. So the trial court correctly denied the motion to alter or amend. Plaintiff appellants, moving to the second issue and argument, plaintiff appellant's proposed amendment did not relate back under Rule 15.03 because it is not this case does not involve a mistake or misnomer regarding the identity of the proper party. This case, similar to the Bennett v. Town and Country Ford Inc. case we cited in our brief, as well as the Towns v. Sunbeam Oster Co. Inc. case we cited in our brief. In both of those cases, the proposed amendment did not relate back because there was no misnomer or mistake. Applying the law of those cases to the facts of this case, again, plaintiff appellant named Erlanger in its initial complaint. There wasn't any confusion. There wasn't a mistake or misnomer regarding the proper parties. Ultimately, in light of the allegations in paragraph 9 of the complaint, there was no mistake. And the impetus of plaintiff appellant's attempt to amend the complaint was essentially the defense asserted by Dr. Gallagher. Put differently, there may have been a mistake as to the consequences of non-suiting Erlanger, but there was no mistake regarding the identity of the proper party.
Was a mistake alleged as to misunderstanding as to who Dr. Gallagher's actual employer was?
No, Your Honor, as we state in our brief in that paragraph 9 specifically indicates that Dr. Gallagher was employed by Erlanger or the spine group which Erlanger owned. And again, plaintiff dismissed both Erlanger and the spine group. So any potential employers of Dr. Gallagher were dismissed freely and deliberately, not based on it.
Spine group's not a governmental entity though, is it?
No, Your Honor.
So dismissing it as to them is kind of different than dismissing it as to the governmental entity, isn't it?
Correct, Your Honor. But again, the important point for purposes of our argument is that there was no mistake regarding who Dr. Gallagher's employer was. This isn't a situation as in the Bidwell case, which we referenced in our brief, where there was some sort of alleged hiding of the ball with respect to who the employer was. And frankly, there was just no mistake or misnomer. Moving to the third component of our argument, the savings statute does not apply to governmental entities in actions brought pursuant to the TGTLA. This is a relatively straightforward and uncontroversial position. It's so much so that it's included in the advisory commission comments to the to Rule 41.01, which says the general rule in Tennessee is that savings statutes may not be applied to extend the period within which an action must be filed under the Governmental Tort Liability Act. We've also argued that plaintiff appellant was required to comply with Tennessee Code Annotated 2926-121 and 122 in connection with this May 23rd, 2019 amended complaint. I'll touch briefly on 121. Following the voluntary dismissal of Erlanger, it was as if Erlanger had never been sued. That's what the case law relating to voluntary dismissals states. So given that it was not a certainty that suit would be refiled against Erlanger, the failure to provide notice to Erlanger of the refiling frustrated the purpose of that statute.
All right. Thank you, counsel. We'll hear from the appellant in rebuttal.
Your Honors, I have only two comments and I'll waive the rest of my rebuttal time, but the two comments are this: I believe, and I'll just look quickly at my reply brief, I believe Himmelfarb, which was relied upon by the appellee, was a one defendant case, not a multiple defendant case where we said an interlocutory appeal. Two, on the saving statute, I will concede that I have not seen this argument made before. So it is a unique argument to say that by amending the GTLA statute to say that if the doctor is an employee of the of GTLA, and if GTLA does not allow use of the saving statute, that is an exception because the doctor was required to be named together with, as alleged, with the hospital. And so if the saving statute works against the doctor, it works against the hospital. And that concludes my argument, Your Honors.
All right, thanks to counsel for both sides. We appreciate your arguments and your briefs. The issues before us, you've made them clear, and we understand your positions. Mr. Hibner, if you will, please adjourn court till our next regularly scheduled docket.
This honorable court is now adjourned.